Okay, good evening everybody. It's great to see such a fantastic turnout for tonight's Grand Challenge lecture. So you're very welcome here to the Institute of Liberal Arts and Sciences. And our lecturer tonight is Professor Iyiola Solanke from the University of Leeds. And it's a great pleasure for me to welcome Iyiola back. She was here not too long ago, but I'll say a little bit about that in a moment. So just to give you the basics, Iyiola told me to be kind of discriminating. Don't have to say everything that's laid here before me, but you can always check out her fantastic achievements, I presume, on your Leeds website. But I will tell you that her current position is as she's a professor at the School of Law in the University of Leeds. She is in the Centre for Law and Social Justice, where she holds the chair in EU law and social justice. And her interests, she did her PhD at LSE. Her interests are quite wide-ranging and I'm sure of great interest to all of us who've come to here tonight. EU law, anti-discrimination law and stigma, weight and law, comparative race and law, intersectional discrimination, critical race theory, social movements, judicial diversity, gender and judging. So quite a wide range of interests that intersect with one another in interesting ways. She has a huge international reputation, having been a visiting professor at Wake Forest University in the United States, at Sciences Po in Grenoble in France, at University of Michigan Law School, University of Sydney Law School, McGill in Montreal, and Newhall, Cambridge. So she has affiliations to all of these great institutions. And in 2018, she was a Fernand Braudel Fellow at the European University Institute in Florence. And last year, or this year indeed, she's also been a visiting professor at Harvard School of Public Health, working on weight stigma. Iyiola founded the Temple Women's Forum North in 2013 to extend the outreach work of Inner and Middle Temples to legal professionals in the North and Northeast. And in 2017, she was elected an academic bencher of Inner Temple. She's also been instrumental as a leader in establishing the Black Female Professors Forum to promote the presence and visibility of black women in the academy. And her most recent book, Discrimination as Stigma, was published by Hart in 2017. So I just wanted to say that last time Iyiola was here, she came because we invited her to be one of the external speakers at the launch event we had for our commitment to the Race Equality Charter. And she gave a great speech, and we had a fantastic event. And as many of you know, we've been working quite hard on that now for well over a year, and we're planning to submit for the Race Equality Charter Bronze Award in February. I think it's been a lot of interesting work. I've been somewhat involved in it myself, and I have really enjoyed the work. I think it's been challenging for us as an institution to really get to grips to the extent to which we're part of the we share as an institution and live in some ways some of the troubling legacies of racism that's been passed on historically and that are still pervasive in all areas of life, the everyday experience of people and so on. And I think the topic tonight promises, I'm certainly really looking forward to, because I think the connection between those kind of individual experiences, which sometimes manifest themselves in legal kind of representation, and a broader kind of social experience, because discrimination has many different levels, I guess, from the kind of formal exclusions from opportunities or whatever, through to just everyday experiences of kind of minor insult or whatever. And I think that was kind of, if we don't understand the social dynamics that are at work and see how they interact with the law, I think we're not going to be getting really to grips with the problems, even intellectually. So I'm certainly really looking forward to hearing. So the title is A Public Health Narrative for Anti-Discrimination Law. So please welcome Iyiola.
Thank you. Good evening, everybody, and thank you, Shane, for that very kind introduction. It always amazes me to hear all of these things that are rattled off that I've done. And I was talking to Joe about this earlier, and the trick to doing lots of things is to think of it all as being in the future. So just say yes, and it's in the future. You don't have to think about it now. You just think about it when you get around to doing it. But of all of the things that I've done, I think that I've really received a lot of satisfaction from the Black Female Professors Forum that I set up last year. But I'll say a bit more about that shortly. So this is my second time to speak in this lovely room. As Shane said, the first time was just over a year ago when the Race Equality Charter was launched here, and that was a really fun event to be invited to and to meet you all. So I'm really pleased to have been invited back to give this grand challenge lecture. I don't know if you'll think this is a grand enough challenge, but I teach discrimination law and I conduct research in discrimination law, and one of the things that I've thought about for a long time, which became crystallized in this book, Discrimination as Stigma, is thinking about how to fundamentally redesign anti-discrimination law in order to remove the focus being solely on the individual. So that's how I came to Stigma, and then going further beyond Stigma, I started to think about the idea of approaching discrimination as a public health issue. So that's what I'll talk about tonight, and hopefully I'll take you all along with me in the various stages of my thinking. Right, so to begin, let's use this. As you are probably all aware, we are celebrating this year the 50th anniversary of a very important piece of legislation, the Race Relations Act 1968. It wasn't the first Race Relations Act. The first one was, of course, was adopted in 1965, and I was involved in events to mark that 50th anniversary a few years ago. And this year I've also been involved in events to mark the 50th anniversary of the 1968 Act. Of course, there will be another commemoration. In 7 or 8 years, we will have the 50th anniversary of the Race Relations Act 1976. And then after the Race Relations Act 1976, we did, of course, have the introduction of the Grand Equality Act in 2006 and then amended in 2010. So we do have a long history in this country of anti-racial discrimination law. Of course, we also have a long history of sex discrimination law, disability discrimination law, and a more recent history relating to religion, age, and sexual orientation and political belief. But just thinking about race again for a second, in 2017 we saw that there were lots of reports. It's amazing how many reports were produced in 2017, none of which had very good news about the progress that we had made in relation to racial discrimination. So we had the McGregor-Smith report, which set out how poorly black and minority ethnic workers fared in the labour market. 14% of the working age population in this country is black, but there is still, she found, structural historical bias in the labour market after 50 years of anti-racial discrimination law. The Lamy report, focusing on criminal justice, set out that there is still a disproportionate number of young black men in particular in all levels of our criminal justice system. And then, of course, the Cabinet Race Audit, which covered many different areas, but very clearly said that the black population in Britain is not faring well. White people are much more likely to own their own homes and to even have jobs than those from ethnic minorities. So the news in 2017 of our success with 50 years of anti-racial discrimination law was not very positive. In addition, you had reports based on surveys conducted by the trade unions, focusing on academia, setting out that black people working in our universities, our higher education institutes, were also subjected to a high level of discrimination. And to give you an example of that, from the UCU survey conducted in 2016, 90% of black workers who participated in the survey said that they faced barriers to promotion. 50% said that they were unsure how to apply. 59% felt that they were not supported with their plans for progress, and 52% felt that they had no positive future with their current employer in 2016. In relation to bullying and harassment, there was 71%, said that they experienced bullying and harassment from their managers, and just a few percentage points fewer, 68%, said that they suffered bullying and harassment from their colleagues. 78% reported exclusion from decision-making, and 82% said that they experienced cultural insensitivity. So charters such as the Race Equality Charter clearly have a role and a lot to do in our higher education institutions. But the main point I wanted to make in showing you these surveys is that after 50 years, again, of anti-racial discrimination law, we sadly have not come far enough. If we think about the gender pay gap and sexual harassment, it's also clear that in relation to sexual discrimination, we also have a way to go. If we think about disability discrimination, I don't think we've even really touched the surface of the amount of disability discrimination that is encountered in this country. So we really do have a lot of work to do. The law is in place, but somehow it's not quite hitting the mark. It's not doing what we want it to do. And so the question that I wanted to tackle in this book was to think about why that is. And to start to answer that question, I went back to think about the basis of our anti-discrimination law. So, as I've said, our law has developed incrementally, with statutes being adopted focusing on specific characteristics. So, race in 1965, sex in 1975, age in 2006, etc. And these statutes have been mutually exclusive. So, for the history of anti-racial discrimination law, it's only been possible to bring a claim on the basis of one statute or the other. That has slightly changed now, but I'll say a bit more about that later. Now, when our legislators were thinking about what type of attributes should be protected using law, the key concept that they used was this idea of immutability. The idea that the law should only be used to protect those who suffer discrimination on the basis of something that they have no control over. An attribute that they haven't chosen, that they can't change, or can change only with difficulty. Which is why, for example, in 1965, Parliament decided to legislate against race, but not religion. So this idea of immutability is embedded in the DNA of our anti-discrimination law, even though it could be argued that we have started to move away from strict immutability. So my question then that I asked myself was, what are the consequences of relying so much on immutability? And my answers were threefold. First of all, I decided because of this concept, we have ended up with blind spots in our anti-discrimination law. So Shane mentioned that I'm now conducting research in relation to weight discrimination. It would be very difficult at the moment using this idea of immutability it would be impossible using the idea of immutability to argue for legal protection against weight discrimination. Because who in this room thinks that weight is immutable? The general social consensus is that we as individuals can control our weight according to our behaviour. So I would challenge that. We can talk about that during the question time maybe. But because of this reliance on this idea of immutability, weight discrimination, or using anti-discrimination law to protect persons from discrimination based on their size, would not be thinkable in this country. There is only one state in the world where weight is specifically prohibited in discrimination law, and that is in the state of Michigan in the United States. The second consequence of immutability for anti-discrimination law is that it focuses on the individual and the idea of this attribute that belongs to them. And it means that individuals who feel they have been discriminated against have to have to themselves use their own resources to bring a claim to stop or prevent that discrimination. So individuals are left with a huge burden. They have to not only have the strength of personality to bring a case against their employer or the relevant organisation, but they also have to have the available resources to pursue that complaint. And discrimination cases tend to run on for a while. They are quite complicated cases to win. And sometimes, even if you win, you end up having to leave your job. So it isn't an easy route to take. So the burden is very much on the individual to bring the claim. And in fact, even if you win, you only win against that particular employer. Imagine if you're unlucky enough to go to another organisation and face the same problem. Well, you have to do the same thing. If you leave your first employer, well, imagine if a colleague has the same problem with the employer. Well, they have to go through the whole process again. So the outcomes, the impact of an anti-discrimination law claim under the current legal framework is also very individualistic. There isn't broader social learning arising from any individual anti-discrimination suit. And then the third problem that I identified is this lurking norm that the concept of immutability creates. So what the law essentially says by using immutability is that we possess these attributes. We haven't chosen these attributes, but there's something that isn't quite normal or standard about these attributes. But because we haven't chosen them, the law will protect us from any disadvantage based on them. So the underlying message is that actually that attribute isn't normal. That is why the law is going to protect us from any negative or discrimination based on that norm because we haven't chosen it. It's not our fault we have it, we just happen to have it. So lurking within the DNA of anti-discrimination law is what I call this, well, it's a white heterosexual male. You know, the closer we are to the white heterosexual male, the less discrimination we will feel. And that, I think, is problematic because that then problematizes the attribute rather than the social response to that attribute. So what I wanted to do was to find a way to move away from the focus on the attribute itself and focus attention on the social meaning given to that attribute. And that brought me to the idea of stigma, hence discrimination as stigma. So the idea of stigma, some of you will be aware, was popularized by Erving Goffman in his seminal book in 1963, where he focuses on stigma as a behavioral concept. And his interest was very much in identifying what happens when a person with a stigma interacts with a person who doesn't possess a stigma. So his interest was very much in the face-to-face interaction. He acknowledged that stigma also does have a social context, but he emphasized more the face-to-face interaction in relation to stigma. That wasn't quite the definition of stigma that I used in this book, because since Goffman wrote his text, there have been more critical social psychologists who have defined stigma as a social process of disempowerment. So a process that begins with labeling, moves into stereotyping, then the stereotypes are used to create a division between those with the stereotype and those without it. Those with the stereotype are then subjected to a loss of social status, and from that lower social status, they then become targets for discrimination. So the idea of stigma that I use in this book is very much one that focuses on social power, because stigmas are not created by individuals. Stigmas are created and perpetuated in public spaces, in society. And from that position, I thought, well, this takes us away from focusing on the individual attribute as something that a person possesses, and turns our attention to think more about the society in which that attribute is given meaning. So I liked this idea of thinking of stigma as a social process of disempowerment, and this quote, the quote at the bottom there, stigma is entirely dependent on social, economic and political power. It takes power to stigmatize. That for me not only brought in the social context, but also brought back into the idea of stigma the idea of power. And that's something that I think we are also losing in our understanding of discrimination. So this social approach to stigma was one that I found very constructive. And then there were further ideas that I found in the works of Herrick, who identified the key characteristics of stigma as being its embeddedness, its endurance, and the fact that stigma is something that the powerful can use to impose upon those who have no power. And then a couple of criminologists talked about the loss of status that is experienced by those who are stigmatized. So they talk about stigma as being something that people do to each other, so the face-to-face element that Goffman highlighted, but also what society allows people to do to those who are stigmatized. So again, you have the broader context of stigma. So having thought about the idea of using the concept of stigma as the rationale for determining who should be protected under anti-discrimination law, I then went ahead and created the anti-stigma principle, which would be something that legislators could apply to determine which groups should be protected by law. So I've tried to create a systematic way of deciding who should be protected by anti-discrimination law. And this anti-stigma principle has 10 questions, beginning with the question of whether the mark is arbitrary. So does the attribute or the characteristic or the status have any meaning in and of itself? The second question would be, does this mark, is it used as a social label? You can see all the questions there. So what I do in the book is then take two characteristics, weight and tattoos, and I apply these questions to each of those attributes to determine what I think would be the 10th characteristic to be protected under the Equality Act. Now, as I was writing the book, my conclusion was that weight should be protected using anti-discrimination law, but that tattoos shouldn't be. Now, you may have questions about that. I'm willing to discuss that some more. My ideas may have moved a bit. But you can also apply this test to things such as smokers. Some smokers will complain that they suffer discrimination because they can no longer smoke inside and they're banished to these dark, smelly places to smoke. Should that mean that they are protected under anti-discrimination law? Or class. I'm often asked whether I now think that class is, or socioeconomic status, is a characteristic that should be protected under anti-discrimination law. So the principle doesn't provide an easy answer. And in a sense, it's not supposed to. Because what I really want us to do as we continue to expand our understanding of equality and so try to expand protection to different groups, I want us to be able to explain why certain groups are protected and certain groups aren't. because I think at the moment we are expanding protection without a clear rationale. So the anti-stigma principle was, as I said, something that I created to create a unified rationale for anti-discrimination law. So having looked at a lot of research conducted on the idea of stigma, which is where most of these questions came from, it then struck me that much of the research was conducted by scholars in public health. Scholars looking at mental health, scholars looking at HIV and AIDS, or at things like epilepsy or Ebola even. And then I started to ask myself, well, I wonder whether it would be possible to think about discrimination as a virus, because that's what public health professionals do, right? They help us to deal with viruses. And I discovered that there were in fact a few scholars, these are critical race scholars in the United States, Morris and Morris, who had already made this analogy. So they talk about the discrimination virus as being similar to the cold or the flu virus. And they say that, well, like the cold and flu virus, discrimination has been around for centuries. It passes from person to person year after year. Discrimination affects the body and the spirit. It's invisible to the naked eye, yet it's highly infectious in the lives of those that have this virus. It passes very rapidly from one person to another, often without the recipients being aware that they have been infected. And it's something that the victims, those who have the virus, recognize it because they know how it sounds, how it feels, and the results of the infection. So, to some extent, yes, discrimination can be approached as a virus. But then, of course, there are limitations to this. The major differences being that the cold virus is something that we hope is short and temporary, whereas the discrimination virus can stay with an individual for their lifetime and also affect the life of a victim every day for the lifetime. Discrimination can also cross generations, and also, of course, there is no inoculation for the discrimination virus. So there are limits to this analogy, which didn't deter me, because actually, for my purposes, what I wanted to do was to use the approach of public health specialists to broaden the way in which we approach discrimination. So if I just go back a slide. When public health specialists set out to deal with a virus, they don't just treat the individual. They also have to take action to address the virus in society. Now, this can be public education campaigns, such as you see here in this graphic. Churches, schools, and shows are closed to prevent the spread of the virus. Likewise, with Ebola, a public education campaign showing the signs and the symptoms of the disease. So, as well as providing medication, Advil, taking aspirin or Lemsip to deal with a cold or a flu virus, as well as getting a jab, the flu jab, or some other vaccination. In order to address a virus, you also need to engage in broader public health, public education campaigns, and sometimes you also just need to spray down the area. So having thought about all this, I realised that there were actually some interesting lessons that we could learn from public health specialists in our approach to tackle discrimination, which would take us beyond the individual litigation approach, which is the norm under the current paradigm of anti-discrimination law. So in order to address discrimination from a public health perspective, we would have to emphasise not only individual responsibility, but also social responsibility. Discrimination would become something that affects all of us, and we all need to engage in to eradicate, and not just those individuals who might be the victims of discrimination. In addition, we would have to introduce or think more about multi-level and multi-institutional approaches to address discrimination. But perhaps most importantly, if we were to approach discrimination as a public health issue, then take in public action, so public education campaigns or spraying down environments, those would become a norm for tackling discrimination rather than the exception which they are at present, because the Equality Act does contain provisions on positive action, but most organisations are just too frightened to use them. So we end up relying solely on beleaguered individuals to bring cases to court. If we take a public health approach, then both sides of the battle become as important as each other. So individuals are not the only ones having to carry the burden to rid our society of discrimination, but those who are not burdened by discrimination equally have a responsibility to do so. And organisations, if they see public action as the norm, will be less reticent to introduce measures that we would now describe as positive action, but under my framework we would call simply public action. So what then are the further implications of this for anti-discrimination law? So this is the work that I was doing when I was at Harvard, doing some work with the public health, in the public health school there. So one of the things that we could then do if we used a public health narrative or introduced a public health narrative for anti-discrimination law would be to think about a different type of language. So we could perhaps focus more on the idea of transmission. How is discrimination transmitted from one generation to the other, perhaps, or from one person to the other? What are the transfer mechanisms? We could think about inoculation from discrimination and immunization from discrimination. We could think about trying to identify early indicators or symptoms of discrimination. And we could perhaps think about mechanisms of emergence. So these are all the concepts that are used by public health scholars to track and predict outbreaks of certain viruses. In relation to the action that we would take to address discrimination, I've already mentioned it would broaden the sphere of action to the public sphere as well as the private sphere. And in terms of the goals, prevention would be as important as providing a remedy. And this would be a remedy that is future focused as well as in the present. So in the last few minutes, what I want to do is think about some of the different tools that might arise if we adopted this public health narrative for anti-discrimination law. Firstly, if we think about diversity as inoculation, which would take us beyond inclusion, and then something that I've started to develop called the discrimination risk assessment tool, which is shamelessly pilfered from something called the DRAT, the Influenza risk assessment tool. So first of all, diversity as inoculation. So we talk a lot about diversity, especially in academia. And it's almost just become a byword for sometimes I'm not even sure what we mean when we talk about diversity now. So if we talk about diversity as inoculation, well, we all know what an inoculation is. It's an injection that protects our immune system from a particular virus. So if we think about diversity as inoculation, that means that we are taking action within our institution to prevent infection from a virus. And for me, that just sounds a lot more substantive than diversity as inclusion, because it means we are not only concerned with who we see, we're not just concerned with numbers, but we really are concerned with the substance, the value, the principles within our organisations. So diversity as inoculation would focus on anti-discrimination. It would be multisensory. It would enable action on intersectionality. It would be multi-level. And we would focus our actions on those areas which are the most homogeneous, for example, academia and the STEM subjects. So that's one of the first practical consequences, I think, of thinking about discrimination as a public health issue. And then the second consequence would be that, the second consequence would be that we could do more future-proofing. So we could think more about taking preventive action on an organisational scale. So the idea of the influenza risk assessment tool is to help public health specialists identify where the next outbreak of influenza might be. So what that would mean in relation to discrimination would be that we think about what indicators there are in our environment that might, if left to fester, result in an outbreak of discrimination. So the discrimination risk assessment tool would be a tool to enable advanced planning and preparedness to address discrimination. The DRAT would assess the risk of discrimination within an organisation and identify action to address and recover from that risk. So this would be a very in-depth, detailed examination of everything that an organisation does and a way to think about everything that the organisation does in terms of the prevention or promotion of discrimination. So that's the DRAT. So to just go back, I skipped over this because I wanted to save it until last. I mentioned this earlier, the Black Female Professors Forum, and this is something that I started to think about when I had finished the book, because one of the things that I realised, having become a professor, is that there are very few black female professors in higher education in this country. Official data tells us that there are 350, but I didn't know, apart from those who I have had personal contact with, where those 350 were. So I just started a very simple project. I didn't think it would last very long or take very long, and just sent out a question on a distribution list asking if my colleagues knew of any black female professors anywhere. And the names came flooding in, which was very nice because ultimately, and I'll stop soon because ultimately it resulted in the creation of the Black Female Professors Forum. And what I've been working on since about February last year is adding as many black female professors to this site as I can. At the moment we have about 130 professors here, and the names really are coming in through word of mouth. So if you know of any black female professors, then please let me know. And as you can see, I'm using black in a very broad sense. I have a definition here. I use black to empower communities, less as ethnic minorities, but as global majorities, and to foster a sense of solidarity in the common struggles that black people face. So you will find professors of African, Caribbean, Asian, Latin American origin on this list. I think it's important not to become focused on perhaps ethnicity, because the issue that we are trying to tackle is institutional discrimination. So I managed to persuade my colleagues that we should use the word black rather than black and minority ethnic or black, Asian and minority ethnic. So the other thing that we discovered was that there are still many universities in this country that do not have a single black female professor across the institution. And those institutions that do have a black female professor usually only have one. So, for example, I am the only one at Leeds, and I think you have one here. I don't know if Farzana is here. She's not here. So there's still a lot of work to do. There are some disciplines that don't have any black female professors. The disciplines with the highest numbers are law, sociology, and education. But theology, architecture, archaeology, I mean, there are still many disciplines that seem closed to young black, female and male scholars. So we do have a lot of work to do in our higher education institutions. And I think that if we think about discrimination in the broader sense that I've talked about this evening as a public health narrative, then we will have a conceptual basis to help us to engage more in tackling these issues. Whereas if we continue to think about discrimination as immutability, we will continue to emphasise the individual enforcement of discrimination law, which is important, of course, but it's not doing enough. So hopefully, if this idea is popular enough, then we will introduce a different paradigm to tackling discrimination so that not in 50 years, but perhaps even in 20 years, we do see a difference in our society, and the discrimination law that we spend so much time trying to create will actually ultimately create the societies that we desire and deserve. Thank you.